summing up, Judicial was all about moving women, law and development forward, whether as standalone or as connected. And for the 35 years that she worked as researcher, teacher, and social activist, she always zeroed in on that. It is not possible for me to take on all the breadth of issues that will come up under women, law, and development. So what I have tried to do is just identify, flag some issues. This is not a full academic paper. So what I have just done is flag some issues. I do not claim that this is exhaustive, but it is just to help us think, and it is to help shape the direction in which our social action should go, and some research for the future. So let me start with women's rights and legal equality. Very early in the life of Nigeria as a nation, it constitutionally recognized legal equality for women. However, legal equality did not always translate to substantive equality. So there is equality in the law. The law says that no person shall be discriminated against on the basis of sex. That's the promise of the law. The law does not say anybody is inferior, but the reality is that our practice did not match and still does not substantially match the promises of the law. Constitutional equality itself was undermined by numerous conflicting legal norms. So you would have constitutional affirmation of equality. Then in some other legislation, you will have laws, you will have provisions that were indicative that the law did not regard women as equal. A lot of those have been documented. I do not want to spend today bemoaning all those issues that have been well documented. Also, there were numerous customary practices that were sustained as customary law, valid under the legal system, that were inherently and obviously discriminatory. And the Constitution or the judicial system affirmed the legality. It was as if there were parallel systems. Even though that was not the intent of the law would say that where custom was contrary to law or contrary to natural justice, equity, and good conscience, custom should not be enforced. But the reality was that there were numerous judicial decisions reflecting that the courts did not regard so many things that were discriminatory as contrary to the law. It was almost as if there were parallel systems. Over the last 30 years, much research and social action at the national and global levels, paced by women such as Judicial have helped us to challenge the status quo. Landmark gains for legal equality since 2008 when she died include judicial decisions clarifying the unconstitutionality of discriminatory laws and practices, as well as legitimization of the idea of women's law. What do I mean by legitimization of idea of women's law? Essentially, when I was going to school, there was no such thing as women's law, because the law was supposed to be neutral. And once the law said something, it said men and women. But today, we are able to say there is law and there ought to be law that responds to women as women, women's specific needs. So let me quickly discuss some of these judicial decisions. By 1997, Nigerian courts were making early efforts to deploy the provisions of the Constitution to advance equal rights of women, as exemplified by the Court of Appeals decrying discriminatory inheritance laws and adjudging them unconstitutional in the case of Mojeku against Mojeku. But the euphoria that greeted the decision was, however, short-lived, as the Supreme Court, when the case got on appeal in Mojeku against Iwuchukwu, the other Mojeku died, so Iwuchukwu was substituted. It was the same case, but the person who took over the estate, I don't want to get legal, let's just leave it as Mojeku against Iwuchukwu. The Supreme Court reversed the lower court's decision, not only on technical grounds, there were valid technical grounds for reversing the decision, but it went on to state that the Court of Appeal position on the unconstitutionality of the Oliekwe practice was in fact obiter. Now, what that means is that whatever the court had said about a constitutional practice that allowed a woman not to inherit her father, and the only way she could inherit her father was by going through a traditional rite that converted her into a man, was unconstitutional. Any comment that the Court of Appeal had made on that, by saying that it was obiter, it meant that whatever, it could not be used as a statement of law, precedent. So that was the consequence of the decision of the Supreme Court. But let's speed quickly into 2018. Today, 10 years after Judicial left us, we can safely say that the Supreme Court has made a turnaround for good. In these two cases, UKJ against UKJ and Anekwe against Unweke, the Supreme Court of Nigeria finally laid to rest that intractable question about the constitutionality of discriminatory rules of inheritance under Igbo customary law. In these cases, the Supreme Court, and I keep saying Supreme Court because that is the final. So once it speaks, it is the law. It can't be reversed until it finds a way of reversing itself in future, which I doubt that it would in this case because it's done the correct thing. In these cases, the court held that the age-long custom which denied wives and daughters inheritance rights on the basis of their gender was unconstitutional. Now, these cases were decided by 2014. Judgment in one was only just delivered last year. But let me say, speed into 2018, the direction set by the Supreme Court is now being followed by the lower courts. And only this week or last week, the Imo State High Court, in a particular case, I do not have the formal citation, but I have the suit number because I only got it out of a newspaper report. But the case decided by Justice Ijeoma Agugwa in Imo State declared that Mrs. Regina Ihemadu, who is the only surviving child of her father, is entitled to, in law, to exclusively inherit the estate of her late father. Not only did the court declare this, the court restrained her uncles, other relations, and their agents from trespassing into the estate. And it awarded 7 million damages for the unlawful trespass hitherto committed. With this decision, we see now the courts are ready, so we can get proper redress. We're moving beyond just an affirmation that says we have equal rights. We're now giving some substance to it. So for the years of trespass, because they had started selling off the property, for the years of trespass, she gets some remedy. It is not just that the court stops at the plan. So with the direction provided by the Supreme Court, it looks like we're inching forward, at least in that area. The criminal law of Lagos State was passed in 2011, and it contains some innovative provisions that respond to the reality of gender-based violence. Unlike before, where you would have to go only under the general assault offenses, the criminal law of Lagos State actually acknowledges that there are crimes that are gender-based and makes adequate provision for responding to them. So it includes, well, I need to say that it didn't really have too much choice. I chaired the committee that drafted the law. So we were able to get in provisions on sexual harassment, which was not existing in any law in Nigeria prior to that time. We were able to get in provisions that criminalize abandonment of a woman that is impregnated. So you impregnate a woman and you abandon her, because we know that pregnancy complicates the health of a woman. And we know that pregnancy-related causes is the major killer of women. So whereas men can be shot by armed robbers, women die from pregnancy-related poor health care. largely. So when a woman is impregnated, we were able to make the case that, look, this isn't about ordinary, this is just about you have accentuated the risks to that person's life, which, and you know, poverty wears a woman's face, which she would likely, you have complicated her life, you have added to her cost, and of course we added considerations of the child's health and survival. You know, if you have, we know that many complications that flow post-delivery are related to the quality of health care during pregnancy. I did read about a case in court some time ago, but unfortunately I asked some of my friends at the Ministry of Justice, but nobody had a record of the case, and this is going to take me to some point I'm coming back to later. Another thing we also added was enlarging the scope of sexual assaults. So we had rape, and everybody knew rape, but the traditional jurisprudence was that rape was penetration of a woman's vagina with a man's penis. And there was always complication as to the nature of other penetrations. Anal penetration, there were complications about what if it's not a penis? And all so we defined an offense of assault by sexual penetration. And we made it akin to rape, because there were those who felt that rape should be preserved as rape. But that was the best we could get. So we have an expansion of sexual assault offenses. Then we have the enactment of the Violence Against Persons Prohibition Act, VAP 2015, and the state equivalent. Now, this legislation, even though it responds to all forms of violence, but is particularly gender specific. And so it takes into account women's vulnerability to violence, higher vulnerability to violence, and its penalties are higher than, and it allows some of the procedural things that it allows other people to make reports aside from the complainant, and so we have innovations in law. Of course, we have numerous gender policies complementing the gender policy. For example, the Nigeria Police adopted a gender policy in 2012. INEC adopted a gender policy. At least we have the documents. Then we will begin to think of how we will make the documents work. With these few illustrations, we can acknowledge that there are incremental gains in the area of legislation that respond to women's rights and legal equality. But I will still say that what we have is greatly insufficient. I would ask, where are we with the domestication of women's rights instruments? So Nigeria has ratified the Convention on Elimination of Discrimination Against Women, CEDAW, as we all know it, the protocol to the African Charter on Human and People's Rights on Women in Africa. But unfortunately, my answer to the question, where are we, is nowhere. We have, for example, in Lagos State, another model project, the Domestic and Sexual Violence Response Team, which has now become a whole institution. It is supported by the state. Through that system, government agencies and civil society all work together. So you have the Nigeria Police, you have the courts, you have the hospitals, then you have civil society, and much more, and we all work together. And commendably, this is an institution that has become replicated in some other states. So we are having some response. And now the state is taking responsibility for addressing issues of justice arising out of domestic and sexual violence. I am only going to speak to the ones that have emerged since then. Professor Akonde died. There were those that were in place before she died. But I'm talking about where we have been in the last 10 years and where we should be going to. Then we also have another model, still talking about institutional responses. We have rape trauma centers all around the country now. Since the opening of Mirabel Center in Lagos, we now have numerous other trauma centers opened across Nigeria. the trauma centers allow. And in at some outing about a year ago, according to the reports from Mirabel Center, so the youngest victim of sexual abuse that they had dealt with was a 2-month-old child. And the oldest was in her 80s. So we do have a huge problem. And there is some effort at documenting, even collating the media reports. Increasing media reportage of violations of women's rights is another issue I want to look at. So we now talk. Before we didn't used to talk. And we should clap up for ourselves now that we have found our voice. I will say that it is media reporting, and I'm using media to include social media, that compels the university to acknowledge and respond to the allegations. You know, in those days, it would have been a newspaper report. And if you missed the newspaper report, that would have been it. But today, it's not going anywhere. And you can circulate it. And I believe that those are some of the things that have started to happen. Social media has helped us with reporting. Last year, I had a student do a research, her dissertation LLM, on gender-based violence and ICT. And we did find, as a fact, that ICT assists us to deal not only with reporting, even providing services. For example, telephone services and all those things. Okay, so the University of Ife had no choice but to acknowledge and respond to the allegations, which culminated in a disciplinary process that led to the indictment and dismissal of the said lecturer. What I would like to highlight additionally is that not only did the University of Ife discipline Professor Ayodele, since then, the at that time, the National Human Rights Commission and the Independent Corrupt Practices Commission got involved with the case. And only yesterday, it was reported that the Independent Corrupt Practices Commission has instituted legal action against Professor Ayodele. Since the OAU case, LASSO has also taken official action to dismiss, I think, 3 lecturers who have been indicted for sexual harassment. Some 20 years ago, some 10 years, some 20 years ago, sexual harassment it just was something that would happen. And you live with it and you go and sort yourself out. It was accepted. But today, universities now have to take official positions and indicate that they acknowledge that sexual harassment is a serious problem, and many of them have official policies against sexual harassment, including my university, University of Lagos, now has an official policy on sexual harassment and romantic relationships. So it's not just sexual harassment. You need to make full disclosure if you are going to go into a romantic relationship with your students, because we know that it undermines academic integrity. So that is where we are. We've gone so far. But what's the inadequacy? We've gone so far, but it is not yet whole. The problem with law, there's a problem with the inadequacy of legal equality. The problem with law, as we know it, is that law does not have the capacity to effect the reform that we wish to see on its own. All too often, practices lag behind law. Currently, there is little evidence, with the exception of maybe what I have alluded to in the area of response to domestic and sexual violence. But there's very little evidence that government at the executive level is committed to working to change in a very systematic way cultures that discriminate, or cultural systems that discriminate against women, by engaging with traditional institutions to elicit commitments and evolve strategies for change. Women who suffer discrimination, I submit that women who suffer discrimination, which have been sustained by years of customary usage, but who have no money to challenge this in court, should not be the ones who are spending their own money to challenge discrimination. It should be the obligation of the state. I would say that if tomorrow, in the light of the decisions that have come out of Anambra State, of Imo State, there is a woman who is still discriminated against in terms of inheritance, it ought not to be her. And only when she has money to get the case to conclusion that she will get justice. It ought to be the state that bears that responsibility. That is aside from the fact that I expect that with such judgments, the state should actually get involved in certain actions to create, some changes in the body policy. And not just that, because that's the weakness of law. How many people knew about the cases I cited until I cited them? So you don't even know that your rights are already clarified in law until somebody disseminates that information. And it is well possible that those who are carrying out the practices themselves do not know that what it is that they're doing is bad. Yes, we have some more law, and we have some more good laws, but weak enforcement undermines good laws. Jadesola Akode was a lifelong agitator for constitutionalism and inclusive constitutions. So let's talk about citizens' participation in governance. I do not know how many people here know that when I think it was the 1989 Constitution Drafting Committee was constituted, again, there was no female. And she had to do a letter reminding them that is there not one wise woman in the whole of Nigeria who can join them? So it is no surprise that one major area that she devoted herself to on the platform of WLDCN and so many other organizations that she was involved with was advocacy for affirmative action. That was one thing that was in the fore. She wrote about it, she wrote about it as an academic. She also worked for it on the streets. But unfortunately, 10 years on, we don't have affirmative action. We lag behind other African countries. Only in the last 3 weeks, I think it's less than 3 weeks, about 2 weeks, Ethiopia had its first female president. Rwanda has affirmative action in its constitution, as a result of which it is one of the leading countries globally.